This is Barry Zalma on insurance. I'm an attorney who is retired from the practice of law and now spend my time acting as an insurance claims consultant, an expert witness, an author, and producer of these videos. Today I'd like to talk about some common employee fraud allegations, including the NICB common employee fraud allegation of a faked, exaggerated injury. An employee fabricates an injury altogether or exaggerates a legitimate injury in order to continue to receive benefit or more time off work. An employee may make injury claims and receive payments from both their workers' compensation carrier as well as a personal health care provider, thereby double dipping. Individuals may also file multiple claims with different employers and may use different names or social security numbers to conceal their claims history. This, of course, allows them to make from these benefits more than they made by actually working. There's also the allegation of malingering, where the claimant suffers a legitimate injury but continues to feign symptoms after he or she has already fully recovered in order to continue to receive benefits. Or the classic working while collecting, where an employee is collecting disability benefits from one employer while working another job in which they perform tasks outside the limitations set by their doctor for the workers' compensation benefits. Monday morning injury is also rampant. This is an injury which occurred outside of work, oftentimes over the weekend, but the employee avoids reporting it or seeking medical attention until at work, at which time he or she claims the injury occurred in the course of their normal job activities instead of getting tackled in a Sunday afternoon flag football game. There are also common fraud allegations that come from employers who misrepresent payroll, job codes, or job sites. A workers' compensation insurance premium is determined in part by the number of employees and their overall risk of injury. An employer can report a smaller number of workers or misrepresent those workers' job duties or job location to conceal the actual risk that any given employee takes on, thereby lowering the cost of insurance. This, in California, for example, is a felony. They can also manipulate the experience modifier, where a company's experience modifier represents the number of workplace injuries over a given time period. The higher the number of injuries, the higher the insurance premium. Businesses can create ghost companies to manipulate the experience modifier. In other words, a company can pose as a new business by changing the name of the company and applying for insurance through a new carrier, thus giving the new company a clean slate. There are also common service provider fraud allegations, such as those from attorneys or medical providers and their relationships. Attorneys and medical clinics may refer patients or clients to one another for financial kickbacks. They may also employ the work of chasers and cappers who will solicit injured parties and refer them to these service providers. Some service providers, specifically medical care providers, chiropractors, and physicians, may bill an insurance company for services which were never provided. This is most common with medical bills for X-rays, MRIs, or other expensive diagnostic tests that were never actually performed. Then there is the template billing or boilerplate billing, where medical clinics fabricate identical injuries and prescribe identical treatment for all patients. They use duplicated or very similar paperwork to support the treatment. For example, in one case where I was retained by a policyholder's attorney to testify as an expert witness on 2 auto accident cases, where 2 separate instances, the medical report the attorney provided to me were identical for both patients, both clients, who had the only difference in their medical report being their name and date of birth. I refused the case, returned the retainer, and told the attorney he should have read my CV to note that I was a insurance fraud expert and that I could not honorably testify on behalf of an injured person who had used fraudulent medical billing. Anti-fraud technology can be an effective method to combat workers' compensation fraud and is available to insurers from various sources. Fraud-fighting tools available to insurers and their investigators include the All Claims database maintained by the Insurance Services Office, in-house computer databases, Internet search providers such as Google, Bing, Yahoo, Axe, DuckDuckGo, link analysis, data visualization, claims scoring tools, and having an experienced field investigator are all effective. When all resources are combined, the chance of success at workers' compensation, insurance fraud, or any other type of insurance fraud is fated to fail. Underwriting, loss, claims, injury, treatment, work, and medical history data are all sources of information that can be used by an insurer to aid in the effort to avoid fraudulent claims. Today, insurers can run database searches against the insured or claimant, and the data retrieved can then be used to complete a fraud investigation. The use of social networking like Facebook and LinkedIn are also sources of information about insureds and claimants that insurers can use in combination with simple database software, sophisticated software to help find and analyze the information to be able to defeat all types of insurance fraud. Employers also commit workers' compensation fraud by misrepresenting their payroll or the type of work carried out by their employees in order to obtain a lower premium. Payroll and category of work done by employees are important information used in calculating workers' compensation insurance premiums because they represent the potential for claims. The larger the payroll and the riskier the jobs, the greater chance that a workman may be hurt while performing their duties. Improperly reporting to the state of California potential workers' compensation fraud is not exclusive. The legislature has made a policy decision to allow civil malicious prosecution claims to be filed against workers' compensation insurers if they maliciously reported workers' compensation fraud. If the legislator had thought that all fraud reporting was within workers' compensation exclusivity, it would never have written the statute as it did, allowing malicious prosecution suits. Employers who wish to avoid higher premiums will change the name of the company or break their company up into various different entities so they can buy insurance for low-risk jobs while hiding those employees doing high-risk jobs from the insurer. This also occurs when an insurer assesses an additional premium on the employer during an audit at the end of the term. To avoid paying the additional premium, it is not unusual for the company to close down or file bankruptcy only to appear under a different name. In most states, workers' compensation premium fraud is a crime punishable by up to 5 years in prison. In the seminal decision interpreting California Insurance Code Section 1871.5 is Tensfeldt v. Workers' Comp Appeals Board, a 1998 decision of the California Court of Appeal. There, a single employee falsely claimed he injured his knee when he got out of a city truck. He actually injured his knee while playing basketball. Tensfeldt was convicted of workers' compensation insurance fraud while the criminal matter was pending. Tensfeldt filed a second workers' compensation claim alleging the true circumstances of the knee injury that was the subject of his false claim. The Tensfeldt decision rejected the notion that Insurance Code Section 1871.5 should be interpreted to completely bar workers convicted of workers' compensation and fraud from forever receiving or retaining any workers' compensation benefits connected with a claim otherwise legitimate industrial injury, without regard for the specific facts of the case. Nonetheless, the court held employee Tensfeldt was barred from receiving any benefits because he lied. He lied about the very fact of compensability. Tensfeldt set forth a three-pronged test for determining whether a worker is entitled to receive or retain benefits of workers' compensation after a workers' compensation insurance fraud conviction. An individual may retain or receive compensation benefits after a fraud conviction only if there is 1. An actual, otherwise compensable industrial injury. 2. Substantial medical evidence supporting award of compensation not stemming from the fraudulent misrepresentation for which the claimant was convicted. And 3. That claimant's credibility is not so destroyed as to make claimant unbelievable concerning any disputed issue in the underlying compensation case. This video was adapted from my book, Zelma on Insurance Claims, Part 109, Second Edition, one of the 10-part volume Zelma on Insurance Claims, which are all available as both Kindle books and paperbacks from Amazon.com. If you found this video to be of interest or use to you and your colleagues, please refer it on. It's free, and please subscribe to my Rumble channel, my YouTube channel, and my blog so you can learn about future videos and blog postings. Thank you for your attention.